Hi, I'm Jim Cunningham, and today we're talking about the family home or farm not in your trust. We're also going to talk about preserving Prop 13 taxes on your property. And the disclaimer, I'm a lawyer, I'm talking. It's not legal advice. Don't go out and do a bunch of stuff based on watching this webinar or this video. Subscribe to our YouTube channel. If you're watching this on YouTube, you can click subscribe. It's very important that you do this. There's a lot of change happening in the tax law, not only the federal level, but also the property taxes in California. So you want to pay really close attention to that. Go ahead and subscribe to our YouTube channel. I'm Jim Cunningham. I'm an attorney and the managing partner of Cunningham Legal. 25 years experience. We have offices in the Capital Region, San Francisco Bay and Southern California. I'm a certified specialist in estate planning, trust, and probate law. And what that means is there's a certification and there's a specialization that lawyers have. And I am one of those certified specialists. So I took an additional bar exam, right? To become a certified specialist, as well as got favorable reviews from attorneys and judges. It's almost like a Yelp for lawyers, if you will. Also licensed real estate broker and securities licensed and insurance license. So kind of a broad background. I stay in my lane. I'm just practicing law. I'm not doing those other things. But today we're going to talk about the family home, the family farm, and Prop 13. And this is, these are really tough concepts to get if you're not living in this material daily, like I do, right? Like people who work at my firm do. We're talking about this stuff every day. But for those of you who are just, trying to learn more about this, I take a very high level approach. And so that's kind of what we're going to do today on a very high level. What happens if your property is not in your trust and somebody dies or somebody becomes incapacitated? We're going to cover that. But something to remember is to avoid probate and to avoid probate court, the property has to be in the trust. Now, we'll talk about how you do that, but it's very important to remember, it's not enough just to name your property, just list it on your trust, on your Schedule A, on your living trust. But if it's not in the trust, what do you do? And what do you do if someone's alive or deceased? So it's a lot different if someone's already passed away. How do you preserve the low Prop 13 taxes? How's the way that we can preserve these for the family going forward? What are the best practices? And I would chalk this up to basic, estate planning hygiene, for lack of a better term. But what are these basic things that we need to do going forward? And that are some of the habits that we should consider if we want to create multi-generational wealth. And then we'll talk about strategies to avoid the impact of Prop 19 on family inheritances, as well as some steps that you can take, frankly now, or you can consider taking to protect your loved ones. So again, to avoid probate, the property must be in the trust. It must be in the name of the living trust. We have a whole webinar on this, on a YouTube video on our YouTube channel. I would really encourage you to take a look at this. We talk about what an estate plan is, what a living trust is. We go through the elements. I'm not going to do that today, but you can certainly take a look at that on your own time. And so what is a living trust? So this is very important to understand. A living trust is a document. It is not a form. It is created during your lifetime, hence the term living, right? Because you make it. You're the grantor, you're the creator of the trust. You're the trustee, you're the person in charge of the ship, so to speak. You're also the beneficiary. So when my wife and I did our living trust, we transfer our home into the living trust. I'm the trustee, my wife is a co-trustee. We live in the house, we use the assets, that makes us the beneficiary, right? We can do that because we're the beneficiary. And there's a trustee, so we're also the trustees. So you need those three elements. But a trust can own real estate or real property. It can also own personal property. A trust designates a responsible person to handle things, and that's called the trustee. So a trust must have a trustee. If it doesn't have a trustee, then it's not a trust, right? So that trustee is responsible for managing the assets. And after you pass away, when that living trust stops being living and it's now a trust of a deceased person, that property is then distributed or otherwise dealt with or managed for the benefit of beneficiaries. So when you die, you stop being a beneficiary of your trust, and then you typically name other people or charities or institutions to receive those assets after you pass away. And a living trust does avoid probate in all 50 states. And I say 50 states because if you have property in France, they don't recognize trusts. You got to do something else. So if you own real property, if you own real estate in France, you need to meet with your attorney, your avocat in France, and because they have special rules on property, so that we don't have here. But probate, and I put here $50,000. The probate fees for $1 million estate in California are $50,000. So it's a lot of money. And probate is a pain in the neck, especially during COVID. Probate's just taken a tremendously much longer period of time. Many estates are frankly in limbo. Rod asks, do you need to live in your existing home 2 years or more before replacing with a new primary residence to get the carryover property tax under Prop 19? Rod, as I read the rules, no, but again, not legal advice. And I think you might be conflating the Internal Revenue Code Section 121 exemption that says you have to live in a home 2 of the last 5 years in order to avoid $250,000 in capital gains tax if you're a single filer, or $500,000 in $250,000 in capital gain if you're a single filer, or $500,000 in gain if you're a joint filer. Anonymous asks, the house is listed in the trust. The trust says it's community property. However, the title is filed under joint tenants listed in the trust. Does the deed need to be corrected to ensure community property to avoid a step-up basis penalty? Anonymous, you're asking a question that is a hot topic among lawyers. If your estate lawyer created this trust, it is likely that there's an issue arose. If you hold property as joint tenants, joint tenancy is not community property. So is that property, if you're to get a divorce, is that property going to be divided 50-50 as community property, or is it going to get different treatment at divorce? And how is it treated at death? Those rules are different. So something important to understand is California law says that title controls. Title controls, and it essentially can trump some community property rights. So that's kind of a tough one. But your specific question is, if the property is listed on the trust, but titles held as joint tenants, to me, it sounds like the property's not in the trust, but we'd happy to meet with you one-on-one and go over that. So if your property's not in the trust, what do you do? So, you might be watching this going, yeah, I did this living trust and my house is not in the trust. How do I get it into the trust? So if you're alive, real property is transferred by deed. It's conveyed by deed. Okay, so your title to your real property in California is transferred by deed to your living trust. And so what this looks like is Jim Cunningham conveys Blackacre to the Cunningham Trust, dated June 6, 2016. And Jim as trustee of this trust dated June 6, 2016. That's how the title reads. So it's the name of the trustee, comma, and then it identifies the trust. That's how most deeds are. That's what you see when you see most deeds that transfer property to a trust. So it has the name of the trustee, has a name of the trust, and typically a date. Now, I will tell you that a living trust, it is best practices to date the document, to put a date that the trust was created. If you restate your trust, which is where you have a living trust, you say, this one isn't any good anymore. I need new language in this trust. You can essentially revoke all the language that's in the trust, but keep the title of the trust so that you have a new document, but you don't have to retitle all of your assets, right? So typically you'll see that, the Cunningham Trust dated, whatever the date is, but there will be the name of the trust and the date. So it's very important to understand that sort of best practices on a deed is you want to identify the trustee, the name of the trust, and the date. If you're dead, your loved ones have to go to probate court is the bottom line. So if you die and your name is on a deed and, there's no joint tenancy, there's no whatever. We can think of, I'm just very high level here, right? Is if your name is on a deed and you die, your loved ones aren't going to be able to deal with that property without going to probate court, okay? If you're incapacitated, what do I mean by incapacitated? Mentally incapacitated, not disabled. So a person who has disabilities is different from the person who is incapacitated, okay? So what we're talking about here is mental incapacity, and that's a little trickier, and we'll talk about that. So if you're alive, you sign a deed. A deed to convey title to real property in California must be signed by the owner of the property, okay, the person who owns the property. And it is acknowledged before a notary public. That is also known as notarized. But notarized is not a technically correct term, but everyone knows what that means. But it means acknowledged before a notary public. So what you'll see is a deed, and then the person who owns the property signs that deed. And then typically on the next page, there'll be another page. Sometimes it's on the same document. There'll be the notary acknowledgement, and that it says state of California, county of, and then some words in there, and then typically a signature and the notary stamp. So it's very important a notary acknowledgement, a notarial acknowledgement in California does require a stamp, and it requires a stamp that can be legible if the document is reproduced. So these are all scanned. And so some states, they'll have a seal, but you can't, if you reproduce the document, you can't see the seal, okay, because there's no ink on it. California mandates that you have to have that an ink seal, right? So that even if you use that embosser, you would then have to put some ink or something to show the seal. So it's very important. Does not have to be recorded, okay? So now this is where it gets a little tricky. You can do a deed, and so in California, it must be signed, acknowledged before a notary public, and delivered. So the classic law school example is I sign a deed over to my son, and I sign it, and it's acknowledged before a notary public, and I put it in my drawer. I have never delivered that deed. So a deed does require delivery. Recording is frankly the best way to show delivery, right? The purpose of recording is to protect third parties, okay? Third party bona fide purchasers for value. So it's very important if you want to like nail this down, we recommend that you sign the deed, acknowledge it before a notary public, and then consider, recording that, because that's really what matters in our society is what's recorded. So the recording fees range. There's an add-on if it's not your primary residence. So they're $10 to $80 per property are the recording fees, and it's $20 more if you do not have a preliminary change of ownership report, which is a form that goes to the county assessor. In the deeds of my properties, I have the trust name and the trustees' names. However, I have not used the trust date. Will there be any problems? FinCat, I would tell you that if you go to any well-trained trust and estates lawyer, we're all putting the date on there. And that's important because it identifies which document. So there might be a question as to, well, what document, what trust are we referring to, right? Is this the trust? Or, because there's no date, you're not able to have that additional identifying information. That would be obviously it's better to clarify that, right? And you might clarify that by filing or recording something at the county recorder. But that's really a title insurance question, because the issue becomes, if you have property that's been conveyed to your trust, but you don't have a date on it, is that going to be a problem when your loved ones go to sell the property? I don't know. I don't have an answer to that question. Judy says, can you use transfer on deeds instead of putting it in the trust? So what Judy's saying is basically there is a deed that says, when I die, this other person gets the property. So there are two problems with that. Well, many problems with that. Number one, it's all a matter of public record. So something to know is that living trusts are private. But the fact, if you you say when I die, this person gets my property. What if that person declares bankruptcy, and you say, gee, I don't want to leave it to that person because they're going through bankruptcy. I want to leave it to somebody else. A bankruptcy court may order you not to do that. It is possible. It's a federal court. Okay. So sometimes they make orders like that. Another thing is Medi-Cal reimbursement. So right now, if you go on Medi-Cal, there is reimbursement to the state. If you use that mechanism, it subjects the property to having to pay back a Medi-Cal bill. And the other part of that is if you become incapacitated, and we'll cover this in a couple of slides, there's a rule that says that we treat accounts differently. If it's just in your name, or there is a payable on death beneficiary or a transfer on death beneficiary or a living trust, those pots of money are treated three separate ways. So it may have some unanticipated consequences. The other issue is what if somebody sells that property, uses a durable power of attorney and sells that property? I'm not sure it's a reliable way to transfer property. And that's something that in our firm, we really don't use a lot. And it is common for clients to say, hey, is this a hack? Is this a way around, having to pay a lawyer fees to do this? This seems really easy. But unfortunately, there are a lot of unanticipated consequences. Anonymous asks, if the title to the property is in the name of the family trust and the husband or wife dies, does the property have to be retitled to the survivor's new trust? Depends on Anonymous. It depends on what the trust says. I would say many times in our firm, we do title it into the name of the survivor's trust. But sometimes the trust will say it doesn't matter whether it's in the name of the survivor's trust or the original trust, it still is in the survivor's trust. So it really depends on what your document says. But if the document says it's distributed to a survivor's trust, you got to follow the terms of the document, right? Unless there's a workaround in there. Venkat said for the trust date, is it when it was created or when it was signed before the notary? Yeah, Venkat, that's a tough one because in our firm, the day you sign it, it's immediately notarized. If you signed it and then later took it to a notary, I mean, this is sounding a little more problematic with that follow-up question. I think you should talk to a lawyer and make sure you got that screwed down. What if you're dead? If you're dead, there's, I mean, does it matter? I don't know. Yes, it does. I say that a little flippantly. But if you're dead, you can't sign a deed. Someone else is going to have to sign that deed, okay? And you've got to connect the dots. If I die owning property in my name and I'm not there to sign a deed, how's my wife going to sell it? We need to connect the dots on that. We need to connect me being on title with my wife selling the property, right? So how do we do that? So there are 4 options, none of which are good. But if this, and this is really important. So if you're watching this because, look, mom and dad died, the property's not in the name of the trust, what do I do? Okay. There's something called a full-blown probate. Full-blown probate is what, we lawyers say, which means, and I put $4 signs. I kind of did this like a restaurant. If you say, I'm going to go out for Indian food. I love Indian food. I'm going to go out for Indian food. And you look, well, some restaurants are $1 sign and some are $4. Does it mean they're better? I know. It just means they're more expensive. I don't know, right? But that's what those dollar signs are. Full-blown probate for $1 million estate, $50,000 in probate fees. That's a minimum of, well, the average is 16 months. The absolute bare bones minimum, assuming that COVID did not exist, the absolute bare bones minimum is about 9 months. That's the quickest we've done them in talking to other lawyers. That's just the quickest you can get it done. The average is 16 months, but that's a pre-COVID number. And I'm telling you, with COVID, the courts were closed. And even now, it's when you file in some counties in California, you're getting hearing dates 8 months out to settle an estate. This is after you've already opened probate. So the courts are backed up. Full-blown probate, that's your option. Probably the most expensive option, most pain in the neck. There's a Hegstad or an Uxtad petition. Now, I'm not making those names up. Those are cases. So if you Google Hegstad or Uxtad, Hegstad is where the property was named, was originally in the trust, and then the client refinanced the property and took it out of the trust, but never put it back into the trust. That's actually really common, okay? What do you do? Well, you go to probate court and it's a single petition, okay? So it's not a 16-month process. It's a, I don't know, 2-3 month process, something like that. Uxtad is a slight variation on the facts. It's where the property never was in the trust, but was listed on the schedule of property. So 2 cases. This varies by county to county, right? Whether they'll even grant these or not. So it's kind of shocking that the law is not necessarily applied consistently. I would say that some courts take a broader interpretation of Hegstad and Uxtad, and some courts take a narrower position on these 2 cases, and they look at each at the underlying facts. And I will tell you, you get 2 lawyers in a room, you can have 3 opinions. And it's the same with judges, is they can see things differently. And it's not that one is right or one is wrong. It's just that they see things differently. So we do see a little bit of variation between counties and between judges, quite frankly, on these petitions. Now, what if the property is of a small value? Now, you may think, what property in California is worth less than $150,000 or less than $50,000? Well, for those people who bought lots in California City, you've got one of those that's less than $50,000. So what do you do? Well, if the property's over 50, but under 150, it's a single petition before the court, much like a Hegstad or Uxtad, a little bit less involved. It does require a California probate referee to value the property, because you see that $150,000 or $50,000. How do we establish that factually? You go to a California probate referee. California probate referee's job, they're appointed by the governor. Their job is to value property for the purposes of the state of California, not counties, but states, for the state. So if the statutory limit's 150,000, then it's a single petition. But if it comes at an under 50, you can do it by an affidavit, but it takes 6 months. So a little bit of time. Now, if you're faced with property out of a trust, seek out expert advice. This is not a DIY. What if you're incapacitated? Typically, people will use a durable power of attorney. But again, you're constrained by the terms of the durable power of attorney. And if the durable power of attorney does not permit you to make contributions of property to a living trust, then you can't do it with the power of attorney. But I would really, don't watch this and go do something. You really do need to consult with an expert attorney before taking action under a durable power of attorney for property management and personal affairs. That's typically the attorney drafted durable power of attorney or the uniform statutory form power of attorney. And that's more like the 2-pager that's actually in the statute in California. But it's very important. If someone's incapacitated, there are a whole bunch of other rules that attach to this. And I did mention, if you have property in your own account versus a joint account, or you're holding it as POD or TOD, which is payable on death or transfer on death, those accounts get a separate treatment under the probate code, and the probate code controls how your property is used for your benefit if you're incapacitated. So all those laws are found in the probate code. So the family home and farm and Prop 13, how do we preserve the low Prop 13 taxes? Well, Prop 19 kind of took the wind out of the sails for a lot of clients. And I will tell you, I've been meeting with a lot of clients. I met with a family yesterday, and I had to give them, the bad news of, look, there's no optimal outcome. These properties will get reassessed when you pass away. But let's look at an example. And I'm going to kind of tee this up by explaining a little bit what Prop 13 is. So this is a home in Santa Barbara that was listed a few months ago, listed for $1.15 million. And this is a really good, it's actually a real home in Santa Barbara. And this is a good example to walk you through just conceptually what's going on. So if you're thinking, man, I've got this house, and when I die, my kids are going to live in this house. How do I preserve Prop 13? There's a way to partially preserve it. And we're going to cover that. So in this house, the property's worth $1.15 million. This is the crazy thing about Prop 13. The property taxes are $1,600 a year on this house. So the next door neighbor might be paying $1,600 a month, right? And this person's paying $1,600 a year. And this is because of Prop 13. So Prop 13 says all property in California, all real property in California is assessed at 1% of its market value when there is a change in ownership. Purchase. You buy a house, change in ownership. Death is a change in ownership. When you die, you stop owning it, and someone else owns it. So what we're talking about is there's a legal and equitable title in our worlds. Legal's title is whose name is on it. All right. If you die owning a piece of property, if I die owning a piece of property, when I'm alive and I'm owning it, I have the legal and the equitable title. The equity, you can think of like the equitable as the equity in the house. Who really owns the economic, the benefit from the house. So when I die, my estate becomes a legal owner, or my living trust becomes a legal owner. The beneficial owner, right? The equitable owner is whoever the beneficiary of my estate is, my kids, my wife, whatever. But whoever inherits under my living trust is we look at that person, because the assessor is going to look through a trust. They kind of disregard the terms of the trust, and they look at who is entitled to the income primarily. Who's entitled to the income from this property. So change in ownership includes sale, gift, and death. And after the property is reassessed, okay, when there's a change in ownership, those taxes can only go up 2% a year. And I don't know of any other state that taxes their property like this. So they can only, and by the way, they do go up 2% a year. They can only go up 2% a year. And that's pretty powerful, because the average California real estate, if you just look at all sales, right, all property values, it goes about 6.2% a year over the last 40 years. And so that 4.2% difference, compounded over time, that's how we get somebody living in a $1.1 million home in Santa Barbara paying $1,600 a year in taxes. Something important to understand is the longer you own the home, the more you benefit from Prop 13, right? Because you've had that 2% increase a year, but the property's going up 6% a year. But remember, everyone's protected by Prop 19. So if you bought a house this year, you are protected by Prop 19, or Prop 13 rather. You are protected by Prop 13 because your taxes can only go up 2% a year. So in this case, when a change in ownership occurs, the property is reassessed at its market value, and the assessor says to the tax collector, hey, tax collector, this thing's valued at $1.15 million. So you go ahead and and prepare a tax bill based on 1.15 million, 1,150,000. So this is the actual tax bill. This is public record. So the name is omitted. There's a lot of public information out there, right? It's kind of scary. But if we look at this, the crazy thing on this is that the house is, this property has a assessed value of 105,000. We're going to talk about this a lot, the $7,000 homeowner's exemption, right? But if the property is assessed at 105,000, the property is worth 1.1 million. But for property tax purposes, it is valued, it is assessed at 105,000 minus 7, so that takes it down to 98,000, because your homeowner's exemption, you know, in this one, percentage-wise reduces the taxes quite a bit, but you know, but if you get reassessed and you have $1 million assessment or $1.2 million assessment, 7,000 doesn't seem like it matters as much. So the basic property taxes are here. Oops. The basic, this is the 1%. Now, this is the base 1%. You can see that Prop 13. These other Goleta Union, Santa Barbara Unified School District bonds, those are a percentage. They are taxed based on a percentage of the assessed value of the property. These other things are, the other ones are fixed charges. So these are almost parcel taxes. So the other ones you see here are going to be fixed charges. And those tend to be on a per parcel basis, meaning, you know, it doesn't matter if the home gets reassessed, those are going to stay the same dollar amount. Okay. And so let's say mom gives the $1.15 million family home to the son. So mom has her homeowner's exemption and she gives it to her son. And so we got, you know, thanks mom. It's a very nice thing for mom to do. Give her son a $1.15 million home. But in this case, and this is really important to understand. So if you're faced with a family home situation and one of the children wants to live in the property when mom and dad pass away, really pay attention to this, because there's a real tax benefit. You can save quite a bit of money. So in this case, the taxes only go up about $500 a year. That's because of Prop 19. So Prop 19 has this last remaining carve out for reassessment exclusion. Okay. So what's really important to pay attention to here is the homeowner's exemption. So what is the homeowner's exemption? Well, it's a box you check in the preliminary change of ownership report. Am I going to live here? Yeah, it's my primary residence. Do I want when I look at my tax bill, if I'm living in the home, do I want the homeowner's exemption? Yeah, probably. You know, you're saving $70 a year in property taxes, but that's really not what I'm talking about, because what's really important, if you're going to have this property go to your kids, what's really important is claiming this homeowner's exemption, because it gives you $1 million reassessment exclusion. It basically subtracts about $10,000 a year from the tax bill, kind of forever, right? For as long as as long as that property stays the family home. So this is really, really important. If you have a home and you want to keep your low Prop 13 taxes, then you need to make sure and think about whether that homeowner's exemption box is checked or not, right? You're going to want to look at your tax bill, because what this does is it drops the taxes that would otherwise be paid. And we'll kind of walk through this here. So if the assessed value is 105,000, the gift of the family home to the son means that 1.1 million of value in the house is not reassessed. Now, when I first started learning about this, when Prop 19 passed, this was very confusing for me. So if this is the first time you're hearing this, it's okay to be confused. It's okay to not get it. And I'm going to talk about this from a couple of different angles, so hopefully you can get the concept. Basically, on a very high level, it reduces your property tax bill by up to $10,000 of what it otherwise would have been. So if the property had gotten reassessed, you can take up to $10,000 or thereabouts off the property tax bill. So mom gives the home to the son. 1.1 million is not reassessed. Within 1 year, the son must claim the homeowner's exemption. And what that means is son's name is on title and he has to claim the homeowner's exemption. He's got to make sure that he's on title and has claimed that exemption within a year. Otherwise, you don't get this $1 million reassessment exclusion. So the delta, or the difference between the value of $1,150,000 and $1,105,000, at that $44,000 number, does get reassessed. So your taxes go up, in this case, $532. And that's a one-time analysis. That $1 million number starting in 2023 is going to be indexed to the cost of housing in California, the broader FHA index. So that number will go up, but it's important to remember that this is a single point in time. So when the transfer occurred, what was the market value of the property? What was the assessed value of the property? If the difference is more than $1 million, there's going to be a partial reassessment. Jay asks, what if the parent had the property in an LLC with the children named as trustees? We're going to cover that, Jay, in a few slides. LLC is now dissolved as trustee. That's probably something you're going to want to talk to an expert lawyer on when you involve LLCs and trusts and people dying. But we're going to cover the concept toward the end of the slide deck. So again, looking at this another way, the assessed value is $105,000. And the difference between the market value and the current assessed value of $105,000 plus $1 million, right? The difference gets reassessed, added to the tax bill. And the new assessed value happens to be $150,000 on the dot. I didn't make those numbers up. Those are real numbers, just kind of a coincidence. What happens if the parent gifts the property to a child with capital gains? Capital gains under current law, if Biden does not get his way, under current law, the basis carries over to the donee. What that means is if I buy something for $1 and it's worth $3 and I give it to my kid sells it for $3, he's going to pay tax on the $2 profit. So it carries over. If you die owning the property, you get what is called an adjusted cost basis. Again, under current law, you get an adjusted cost basis. So if I hold on to that thing I paid $1 for that's worth $3 and I die and my son inherits it, he can sell it for $3 and not pay any tax. Very powerful tool. The $1 million is, as I said, indexed to the FHA home values. And, so this is an interesting one, timing of the transfer. So every February 16th, starting in 2023, this $1 million number is going to go up. So if you're contemplating a gift to a child, you may want to pay attention to housing prices because you might get more exemption if you wait a little bit, right? And so it's huge, Prop 13 taxes, preserving Prop 13 taxes, tremendous benefit. Even with Prop 19, you're saving $50,000 over a 20-year period, which is, basically a generation. And the taxes on the 20-year, during that same 20-year period, the taxes without Prop 19 family home exemption are $302,000. So $250,000 delta. So a really big difference. Would you please define FHA again? Thanks. Federal Housing Authority. Federal Housing Authority. Federal Housing Authority is there to protect consumers, right? Help you enforce your rights, avoid a lot of bad stuff that can happen. But the Federal Housing Authority is promoting home ownership for Americans. So Prop 19 saving over $250,000 a year. It must be the family home. The taxes go up. I think the taxes go up if the son ever stops using the home as the family home. I think if you stop having it be your homeowner's exemption, we're not quite sure. We're not quite sure what's going to happen. I've talked to people who are making the rules, and a lot of it is there. We're looking for guidance still on it. So again, this $1 million exemption is applied at the date of transfer. So it's kind of a snapshot. You're not looking at this every year, right? It's when that transfer occurs. Transferring property under Prop 19, very generous benefit. Okay, so if you're a homeowner in California, if you're over 55, which means 55 and over, then you can transfer your Prop 13 property tax base up to 3 times. Pretty cool. It's in within county, out of county. It's going to be in California. If you're moving to Nevada, you can't take your Prop 13 taxes with you. You got to leave them here, right? If you're selling a property and buying another one in Nevada. But this is another wrinkle. There was a prior law that still is on the books that says you can transfer your property tax base once, but the property cannot be of greater value. Well, Prop 19 is really interesting because if you buy a home of greater value, they just add that to the tax bill. It's really kind of amazing, right? So if you have a home you sell for $1 million and you buy a home for $1.1 million, $1 million of the new home is not reassessed, and only that 100,000 is reassessed. So pretty cool benefit. So I pulled here, there was a letter, a letter to the assessors from the Franchise Tax Board and or rather the Board of Equalization. So this letter to the assessor from the Board of Equalization, they are answering questions because the Board of Equalization it equalizes the laws among the counties. That's why it's called Board of Equalization. And part of their mandate is to train assessors on what the law is and give the assessors guidance so that one county doesn't apply the law differently than another county. Rod says, I thought this didn't apply to the Santa Barbara area. No, it's the Prop 19. You're thinking of the older exemption, not one of the 10 counties. I don't think Santa Barbara was one of the 10 counties, but this is now Prop 19 throughout the state. So the question is, for the purposes of a base year value transfer under Prop 19, what is the date of the transfer? So what they're talking about base year value is your Prop 13 tax. So another way to ask this question is, for the purposes of a transfer of your Prop 13 taxes under Prop 19, what's the date of a transfer? Because this became effective on a certain date. And it says, if you do the property on this date or that date, then different rules apply. The date is either the date of sale of the original property or the purchase or new construction of the replacement primary residence. So if you sold your house in January before the effective date of Prop 19 and you bought a replacement property in June, you can use Prop 19. If you sold your house in January of 2021, because we're in 2021, sold your house in January and bought another one in January, you're not going to qualify for Prop 19. Okay, so one of these transfers has to occur, one of these transactions has to occur before the effective date, which is April 1st of 2021. Must both the sale of the original primary residence and the replacement residence. So you're going from Santa Barbara County to Placer County. Do those have to occur? Do both of those have to occur after April 1? So it's the same, it's a similar question to the prior one. No, only one of those transactions. So if you move from Santa Barbara in February and you buy your replacement property in Placer County in April, you can use Prop 19 to transfer. So what we're talking about by transferring your Prop 13 taxes is that Santa Barbara example where you sell your house for $1.15 million, and then you move to Placer County and you buy something for $1 million or $1.15 million. You're going to keep that low $1,600 tax bill every year. So very, very powerful and huge property right. So can the replacement primary residence be purchased prior to selling the original primary residence? The answer is yes. Kind of cool. I mean, we can think of a lot of hypotheticals there. So if you already own it, can you just kind of move your Prop 13 taxes? The answer is yes. Anonymous asks, my mom's house is in a living trust. Would I be able to preserve or transfer her property taxes after she dies if I make her house my primary residence for a time, then later rent it for several years, but then make it my primary residence once again before selling the property and transferring the original property tax base to another house I purchased in California, and I'm over 55. Anonymous, as I read the rules, while you are occupying the property as the family home, you are not reassessed. So mom passes away, you move into the home, you make it your primary residence. 3 years later, you decide to rent it. You lose the family home exemption. The question that I don't have an answer for is, can you get it back? Do you use it or lose it? And if you lose it, is it gone forever, or can you reclaim that? I don't have an answer. And so if I sell my original primary residence in March 2021, but I wait until after April 1, 2021 to buy a replacement residence, am I eligible for a base year value transfer from my original primary residence to my replacement primary residence? Yes. So if you sell your home in March and buy one in April, you're fine. It's basically, it's the same question asked different ways, right? And the purpose of me kind of repeating is sometimes you have to hear this a few times before you understand the concept. Now, here's me spitting out my cereal when I read this, because when I read this, I couldn't believe it. This is amazing, okay? Can I have a co-owner on title and still qualify to transfer my base year value under Prop 19? Yes. There's no requirement. that the person who's transferring their base year value be the sole owner. You can just transfer it. Now, I don't know where to go with this, but here's what's happening. There is a new specialty field, subspecialty field emerging in California law, which is preserving your Prop 13 taxes. Because guess what, folks? It just got a lot harder to do. But I think if you hire an expert lawyer, there might be some wiggle room in here, right? There might be a way to preserve that Prop 13 taxes, tax base in ways that you didn't know were possible. So let me give you an example. This is a real world example. I had a client reach out to me before this letter was released in May. So Prop 19 passes. She says, Jim, I missed the ability to save my Prop 13 taxes and give the property to my kid, but I wouldn't have done that anyway because I live in a condo on the peninsula south of San Francisco, and I want to move to Sonoma County. And so the client said to me, I have enough from the equity I get from my condo. It's not enough to buy the house I want in Sonoma, and I'm retired now and I don't make enough income to qualify for the mortgage. Okay, so what it is a person wants to sell their condo on the peninsula in San Francisco and move to Sonoma, and she wants to know, if I buy that replacement property in Sonoma and put my son on as a co-owner, can I still transfer my Prop 13 tax base? The answer is yes. When I read this, I could not believe it, right? This is a huge benefit. This is a huge potential for planning. And really, I will tell you, this frees up people to sell a property and move, maybe to be closer to grandkids, whatever it is. But you're not as stuck on the house, I think, on the primary residence, at least. You're not as stuck as you were before Prop 19 became law. So I think there's a real positive. If there is anything positive about Prop 19, it's certainly this. So question 20 is, and I'm kind of skipping through these. These are questions, I identified them in the assessor's letter. If my original primary residence is a multi-unit property, okay, am I still eligible to transfer my base year to a replacement residence? Yes, but you'll only be eligible for that portion of the value attributable to the unit of your original primary residence. So if you live in a 3-unit building in San Francisco and you want to sell that and move to Napa, there is going to be an apportionment. Okay, there'll be an apportionment, and they'll look at so it'll be a partial. It won't be a complete. So this is another interesting one. So I hate to say this is timely. As we're recording this, a lot of people have lost their homes. Our firm was particularly affected. Friends of staff, close friends, multiple people lost their homes. So this is, it's kind of hard for me to talk about because it's such a devastating loss to lose your home to a fire. But if you're not 55 and you are the victim of a natural disaster, look at here. This is a real question. Okay. And by the way, these questions are questions that people have actually asked the Board of Equalization, and they're answering them and they're making them public. So I'm a homeowner who lost my home in Napa County in the wildfires of 2017. I purchased a replacement property in Santa Barbara County on October 9, 2020. I intend to sell the original primary residence in Napa County sometime during the 2021 calendar year. Must I sell my original primary residence in Napa County on or after April 1 of 2021 in order to qualify under the Prop 19 provisions to transfer my Prop 13 taxes from Napa to the new Santa Barbara property? So what's happening here is this individual sadly lost their home in the wildfires of 2017 in Napa County. And so that's when the disaster occurred, 2017. They purchased the replacement property in 2020, but didn't sell the Napa property. Now, when they go to sell the Napa property in 2021, can they transfer their Napa Prop 13 taxes to their Santa Barbara property and pay less property tax is the question. So the answer is, once your Napa County property is sold, you'll be able to file a claim with the Santa Barbara County Assessor's Office to transfer your base year value. So the answer is yes. Now, the longer answer is, under Prop 19, your Prop 13 taxes of your original Napa property, in this case, can't be transferred until the Napa property is sold, right? In addition, at least one transaction, either the sale of the Napa property or the purchase of the Santa Barbara property, had to happen on or after April 1 of 2021. And as we saw, the Napa property hadn't yet been sold. So as long as you sell your damaged or destroyed home in Napa on or after April 2021, you'll be able to transfer your Prop 13 taxes to your Santa Barbara home. So for those of you who are watching this who have lost a home in a fire, you know, I think this is good news. I mean, if there can be good news out of a disaster like that, I think it's good news. Shelley asks, so if I inherit a place, live there, then sell it if I'm over 55, transfer the tax base, then after living in the next home, turn that into a rental, will I keep the original tax base? Shelley, I think what you're asking is, if you inherit a property from a parent and you live there as your residence, you then sell that one and buy another one, can you transfer your base year value? I don't know. I think you can, but are you then still subject to the family home exemption? I don't know. I don't have an answer to that question. That is not in the Q&A. Okay. I mean, that's not in the assessor's letter. I just don't know. Deborah says, my father sold the house to me before Prop 19's effective date. I want the parent to child exclusion. I did not record the deed and notarize until after Prop 19 passed, but I finished buying the property from my father a few months before the effective date of Prop 19. Shall I send a declaration from my father with a parent child exclusion form with the assessor to explain why the date of transfer is actually before the Prop 19 effective date? Deborah, you're going to want to talk to a lawyer on that one before you contact the assessor's office, okay? Because remember what I said is a deed, in order to be valid under normal circumstances, must be signed, acknowledged before a notary public, and delivered. If it wasn't acknowledged before a notary public prior to Prop 19, that may or may not matter. I don't know. That's a legal technical question, and I would really strongly urge you to seek out a lawyer. I mean, certainly our firm can help you, but there are several other firms in California who could give you that answer, but I would get legal advice on that one. Sheila asks, my house is in a trust and I've been renting it out for 3 years. Are the property taxes going to be reassessed because of Prop 19? Sheila, no. Okay, so a lot of people thought that Prop 19 meant loss of Prop 13 and that all properties would get reassessed. It is only when there is a change in ownership, right? So it's a sale, a gift, or a death. Anonymous asks, if elderly parents move from their primary residence into a nursing home and the home is converted into a rental to provide income and avoid a large capital gain from sale, is the home now no longer able to be transferred to a child with the $1 million reassessment exclusion in tow after the parents' deaths because the home was no longer the parent's primary residence? Anonymous, I believe you're correct. Okay, again, not legal advice. Based on those facts, hypothetically speaking, if it's not the family home, if it's a rental, it's not the family home, right? You can't claim your homeowner's exemption if you're renting the property out. So it's a little bit of a Sophie's choice. Do you pick capital gains tax or do you pick property taxes? I will tell you, when we've looked at those, in most situations, it makes more economic sense to get an adjusted cost basis at death than it does to avoid reassessment. So when you model it out on the dollar side, but again, very case by case basis. Sheila asks, we have a vacation home owned by 4 of us. 3 of us have our portion in a trust. One owner is 80. When an owner passes, I was told the portion of the ownership property would be reassessed. Will be substantial increases. I'm the 4th generation to own. Would a dynasty trust work to help avoid this? Sheila, you'll see, we'll cover this, potentially an LLC. You could consider an LLC, but also if you're the original owner, there are separate rules on that that we're not going to cover here today, but I would pay attention to the LLC portion. All right, how do you protect your loved ones? I would say consider claiming the homeowner's exemption on the parent's residence prior to the change in ownership, and then the child claim the homeowner's exemption within a year of the change in ownership. Those are the pieces you need to claim that $1 million reassessment exclusion under Prop 19. And it's lost if the family home ceases to be the family home. It's lost. That's what the law says. Let's talk about the family farm. I was really involved with, once Prop 19 passed, there were several meetings that the Board of Equalization, public meetings, right? Anyone can go to, they were by Zoom. I will tell you, if you own a farm, you really need to thank your Farm Bureau, because the California Farm Bureau was instrumental in convincing the Board of Equalization that you get $1 million per parcel exemption, per parcel. You don't have to live on it. And the kind of the joke is, like, family farm, you think of like an old farmhouse on a farm with cows and pigs and chickens. No one has a farm like that, right? It's, you've got 80 acres of almonds, or you've got, 60 acres of strawberries. We do farming a little bit differently here in California, but it's any property that's under cultivation, or which is being used for pasture or grazing, or that is used to produce an agricultural commodity. Okay. So it's $1 million per parcel exemption. So if you have a farm that has 6 parcels, you get a $6 million reassessment exclusion. Now, the family farm of the parent must become the family farm of at least one eligible transferee or child within 1 year. So if the transfer is to a family farm, if the transfer is of a family farm, you do not need to file a claim for either the homeowners or disabled veterans exemption. A family farm is not required to include a principal residence to qualify for this exclusion, and it is a per parcel exclusion. Does disability, Christian asked, does disability of one spouse qualify for transfer of our base year value? I would think so. It might hinge on whether it's community or separate property. I don't know. So I don't know, but probably. Okay. But you would want to definitely check with the lawyer or call the assessor, right? Most assessors, well, I mean, many assessors in California answer the phone, not all of them. Sometimes you actually get the elected official. Call Mono County and you're going to, you might get the elected official. It's a small county. Strategies to avoid the impact of Prop 19 on family inheritances. So Prop 19 took away the Prop 58 parent-to-child reassessment exclusion. And so what people are looking at are entities. They're looking at LLCs. So when an LLC is the original owner, and I'll explain what this concept is, when the LLC is an original owner in a transaction where the property was reassessed when the LLC acquired the property. So you go and you buy an apartment building with an LLC, the LLC is the original owner. And so long as no one gets more than 50%, or there's no control that passes from one person to another, the property's never going to get reassessed, ever. This is really powerful. If you're looking at creating intergenerational wealth for your family and you own, or you want to own California real property, take a real close look at this. And here, I'm going to walk you through an example. Andy creates Franklin LLC to buy a multifamily home in for 500. This happens to be on Franklin Avenue in LA. Franklin LLC to buy a multifamily home in 1986, pays $500,000. In 2021, the assessed value is $1 million, but the market value is $3 million. And in 2021, Andy gives 50% of his LLC units to Betty and 50% to Charlie, his kids. No reassessment. None. Pretty cool. Let's say Andy creates the same facts, but Andy gives 51% to Betty. He likes Betty more. And he gives 49% to Charlie. Full reassessment. Property taxes are going up $25,000 a year. Full reassessment. When an LLC is not an original owner, what do I mean by this? I'm an example. When the property was later put into an LLC, but not reassessed when it was put into the LLC, so long as you retain the same proportional interest, there's no reassessment when the property is transferred to the LLC. But as you'll see, if Andy buys the same multifamily in 1986, but in 1990 contributes the property to the Franklin LLC, the assessed values $1 million in 2021, and Andy gives 50% to Betty and 50% to Charlie, full reassessment. Property's fully reassessed. Now, Betty and Charlie become original owners at that point, right? So going forward, that's a good thing. But in this case, when Andy gave 50% to Betty and 50% to Charlie, because Andy gave more than 50%, the entire property is reassessed. So very important to understand, full reassessment. Now, if Andy gives 50% of his shares to Betty and keeps his other 50%, there's no reassessment. And see how that works? As long as you don't get more than 50%, there's no reassessment. So here's the big insider legal tip. Consider acquiring property that you intend to hold long-term with an LLC at acquisition or shortly thereafter. What I mean by that is, you could buy a property in August and in September put it into an LLC and have it reassessed. It's not going to be reassessed hardly at all, but you would want to intentionally trigger that reassessment, if you will, even though it's only a month, that reassessment so that the LLC becomes the original owner. Now, if you bought a property 3 years ago and you put it into an LLC today, you can still do the same thing. Your property taxes would go up a little bit, probably not too much, but a little bit, right? But you get original owner status on the LLC. And I would say on all of this, this is the A Team. I loved that show when I was a kid. But you need to assemble your own A Team, and I would say it's a blend of different advisors depending on the situation, but typically involves a lawyer, CPA, financial advisor, banker, insurance agent, realtor, right? But typically the three core professionals are going to be the lawyer, the CPA, and the financial advisor. And the purpose of the financial advisors, they can do forecasting and modeling. They're really good at that. CPAs are really good at understanding consequences. If you do this, then this is the consequence. And lawyers are kind of good at taking a longer term view, a multi-generational view, and legal counseling to the client. So that's our training. So again, subscribe to our YouTube channel. And if you'd like to reach out to us, you can go to our website. You can call us, right? So if you're not in the US, you can dial our toll line, a toll free. I don't even know if anyone worries about long distance charges anymore, but we do have an 866 number. We do have a chat feature on our website. Some people like to contact us by chat on our website. You can also email us at team@CunninghamLegal.com. And we do meetings by Zoom, in person, and by phone. We do have a mask requirement. If you come to our office, you do need to wear a mask. And if you don't want to wear a mask, then we can meet you by Zoom. But again, we make it easy for you to work with us. And here's our website here. And this is our main website, CunninghamLegal.com. You can see that orange button at the top, request an appointment, if you would like to meet with somebody. So we'll open it up for questions. Thank you, Alola. Thank you. Kim asks, what happens if a property is transferred to a living trust? Well, typically a living trust is considered an alter ego. Nothing, right? There's no reassessment. If you're the owner and you transfer it to your living trust, as long as it's for your benefit, there's no reassessment. Anonymous asks, can property inherited by two children be structured with the LLC strategy such the inheritors become the original owners going forward for the potential benefit of the children? Well, if two children inherit a property, Anonymous, so long as no more than 50% of those LLCs are transferred, there's no reassessment. So I would say that to get original owner status, to accomplish what you're talking about, the property must be reassessed. Okay. So it has to be reassessed when it goes into the LLC. So that's something we could there might be some alternative strategies that we could talk about one-on-one. They're very case specific. Christina asks, would the LLC solution work for rental properties? Yes. If Andy owns the rental property, a single family home, as well as another home, his residence. So typically we don't put residences into a limited liability company or limited partnership. We keep the personal use assets out because an LLC is for business. So this is a common question. In our firm, we generally don't recommend that people put their primary residence into an entity because it's a personal residence. If you talk to other lawyers, they might have a different opinion, but we're taking a little bit more conservative approach on that. Judy, thank you. Well, if there are no more questions, well, looks like there's another question. Anonymous asks, is there any movement to modify Prop 19 and bring back Prop 58, like parent to child reassessment exclusion? Yeah, so the SB 668 is dead. The Assembly Constitutional Amendment 9, I don't think it's not gone anywhere to date. That might be the Howard Jarvis Taxpayers Association. I think they're working on something. I don't know if there's enough. I don't know if it'll come back on a ballot initiative. Half of Californians are not property owners; they're renters, and I don't know that they really care. With that, great to spend time with you, and we look forward to seeing you again.